If you've lived in Las Vegas for very long, chances are you've heard a local say at some point that the city was better when the mob was here. While we are a far cry away from the days of Bugsy Siegel and Tony Spilotro, Las Vegas is still one of the most corrupt cities in the world. In 2015, the Center for Public Integrity gave Nevada an F in a state integrity investigation. As long as there is money and power to be had in Las Vegas, there will always be corruption. Throughout the history of Las Vegas, that corruption has taken many forms. While the mob may not be running Las Vegas anymore, you have to wonder if some of the people who took down the mob didn't just become the new bosses. The question is, who are those new bosses? According to Nefi Kaliki, a firearm defense trainer and simunition instructor in Las Vegas, it may be the Nevada Sheriffs and Chiefs Association. Organized in 1953, the NVSCA has its roots right smack in the middle of the mob era. They are, among other things, lobbyists who lobby for sheriffs and police chiefs in Nevada. Now, Kaliki is suing the NVSCA and LVMPD over a wide range of allegations, including privacy violations, due process, and oppression under color of law. Regrettably, Sheriff McMahill is dealing with some serious problems he inherited from previous sheriffs, said Nefi Kaliki, founder of the Concealed Carriers Union and plaintiff in the district court lawsuit. We are very supportive of Sheriff McMahill and have complete confidence that he will do what is in the best interest of the citizens and the department. History of concealed carry, permitting in Nevada. In 1995, Nevada became a shall-issue state for concealed weapon permits. SB 299 was codified into law as NRS 202.3657, which original Y gave the power to the Department of Motor Vehicles to issue CCW permits. LVMPD and the NVSCA both opposed passing the bill that would make Nevada a shall-issue state. During his testimony before the state Senate, NVSCA lobbyist Eric Cooper referred to would-be permittees as wackos, weirdos, and perverts. As the law went into effect, chaos immediately ensued as various sheriff's departments began approving vastly different training courses that had no semblance of order or consistency. In the very next legislative session, 1997, SB 128 was introduced that modified NRS 202.3657. During the legislative discussions, a great deal of emphasis was placed on instructors, training standards, uniformity, and consistency throughout the state. Most of the senators wanted the state police, Nevada Highway Patrol, to handle the task of creating training that would fulfill the statutory requirement for training. NHP didn't want the responsibility and argued that the ranges were always full and could not accommodate the public. The NVSCA, who had originally opposed the bill making Nevada a shall-issue state, came to the table with training standards they had created. Senators immediately began to question how a civilian organization could fulfill a role that clearly fell under the purview of the government. Lobbyist for the NVSCA, Eric Cooper, went on record and testified to the Nevada State Senate that the NVSCA would only need quasi-jurisdiction and the organization would only certify the contents of the courses, not instructors. And due to the gross failure in departments achieving consistency and uniformity in training courses, coupled with a lack of agencies volunteering to take on the issue, the state legislature faced the prospect of a new law becoming legally impossible to enact. The NVSCA took advantage of the Nevada State Senate's desperation and made a power grab that was way above their pay grade. Regrettably, the state legislature is learning why we don't give civilian organizations power to act on behalf of the government in any capacity. Several state senators and legislators have pledged to address the issue in the next session. NVSCA lied to the Nevada State Senate. The plight of the Nevada Sheriffs and Chiefs Association may have had its genesis when NVSCA lobbyist Eric Cooper lied to the Nevada State Senate when he said the organization would certify the contents of the courses, not instructors. Today, the NVSCA has expanded its own powers to include investigation, discipline, and the decertification of instructor licenses. Had the state legislators not been in such a desperate situation, they might have realized that it was unwise to put LVMPD and the NVSCA, an obvious conflict of interest, in charge of managing a right both organizations opposed. NRS 281A-020 states that a public officer or employee must commit himself or herself to avoid conflicts between the private interests of the public officer and those of the general public whom the public officer serves. Trademark violations and impersonation. The official logo of the NVSCA includes the official seal of the great state of Nevada, something that is prohibited by NRS 235.010. The statute carries with it criminal provisions for violating the law in the use of the seal. A person unaware of the Nevada Sheriffs and Chiefs Association's legal status could easily mistake them for a government agency. Unfortunately, many people have mistaken them for government, despite evidence that suggests the NVSCA is a fraudulent organization marauding about as if they were government. The truth is, the Nevada Sheriffs and Chiefs Association was only given the power to create training standards. In NRS 202.3657, the statute clearly states, except as otherwise provided by this section. That is legal terminology for, if it's not specifical I said here, there is nothing else implied. The NVSCA has gone far beyond the authorizations they were given by the state legislature, such to the point that they are systematical, violating the rights of citizens. The new law created a regulation for Nevada sheriffs. In NRS 202.3657, it states that a sheriff may not approve a course in firearm safety unless the sheriff determines that the course meets any standards that are established by the Nevada Sheriffs and Chiefs Association. To the NVSCA creating standards, CCW instructors owing them, and students having it applied to them, standards have their natural meaning. To the sheriff's departments, those standards become regulation when they are adopted and applied by the departments. When the state legislature gave the NVSCA the authority to create standards, the NVSCA gave their word that they would only certify the contents of the courses, not the instructors. Clearly, they have gone far beyond that limitation. The state Senate was in a desperate situation, looking for a way to save the law from being unenforceable, and they trusted the NVSCA to be honest about their intentions. As such, the state legislature did not include in the statute any provisions on oversight regarding the NVSCA. That does not mean there is no oversight. When the law is silent on an issue, the power rests with the courts to decide. Under NRS 280.307, sheriffs are allowed to make regulations, but those regulations must not conflict with the regulations prepared by their boards. Any regulations adopted by that sheriff must also be in compliance with the law. This means that any standards created by the NVSCA, which are then statutorily adopted by sheriff's departments as regulations, must also be lawful before they can be adopted, applied, and enforced. While NRS 233B045, the Administrative Procedures Act, specifical Y speaks to state agencies, it lends assistance in revealing the intent of the legislature in defining how various agencies administer laws that are passed. The Legislative Council shall treat regulations adopted by entities other than agencies in the same manner as regulations adopted by agencies if the entity is required by statute to adopt the regulation. In this case, the sheriff's departments in Nevada are the other than agency because they are not state agencies. Sheriff's departments are subject to the Administrative Procedures Act when it comes to a citizen being denied a concealed weapons permit, but the law is silent on specifically enumerating instructors and how they interface with that process. If the reason for a denial for a concealed weapons permit was due to an error of the instructor, would not that instructor then be required to answer to that statute? Because the NVSCA has exceeded their authority and is now in fact decertifying instructors, we find ourselves facing the question of applicability, jurisdiction, and oversight. The actions of the NVSCA are now affecting the constitutional rights of citizens whose licenses are constitutionally protected property interests. Gilman v. State Board of Veterinary Medical Examiners. It will be up to the 8th Judicial District Court to decide what to do about it. Preemption law in Nevada. It is common sense that a sheriff's department must only adopt regulations or policies that are in compliance with the law, even if they are statutorily required to follow those regulations. There is plenty of case law to support this concept, so the reader's common sense will suffice. This fact reveals a far more interesting problem the NVSCA has created by abusing the power given them by the Nevada State Senate. In 2015, the state legislature passed preemption laws that reserved exclusively for the state legislature the power to regulate and define firearms and ammunition. In NRS 244.364, the state legislature specifically states that no county may infringe upon those rights and powers. The statute goes on further to state that any ordinance or regulation that is inconsistent with this section, and that is otherwise lawful, is void. In that spirit, the NVSCA's most recent version of their training standards attempt to redefine firearms and ammunition. A live round has a cartridge consisting of the case, primer, propellant powder, and a metallic projectile. Use of simulated ammunition, such as simunition copyright or other similar training rounds, are precluded from use in the firearms qualification. NVSCA Training Standards 2023. While the NVSCA can define firearms and ammunition any way they like as a civilian organization, a sheriff's department cannot adopt those standards as regulations if the provisions of those regulations demand an action or preclusion that is unlawful. What's worse, the NVSCA specifically created that definition to single out one single person. CCW instructor Nefi Kaliki. Privacy violations. NRS 202.3663 makes the personally identifiable information regarding a CCW permit holder private and confidential, and by statute is excluded from the Public Records Act. That means that the information about a citizen's CCW permit cannot be revealed through a public records request. The standards created by the NVSCA provide that while an instructor doesn't have to have a CCW permit to qualify as an instructor, they do have to have the ability to have a permit. That poses an interesting question, because how could the NVSCA be privy to any of those facts without the Sheriff's Department violating NRS 202.3663 by giving them that information? LVMPD's Policies and Procedures Manual states that police officers will not release information verbally or through any written or printed material, including computer printouts, concerning the operations, investigations, or administration of the department, unless so authorized. By their own admission in writing, LVMP provided the results of their investigation to the NVSCA regarding instructor Kaliki. Providing that information to the NVSCA not only violated department policy, it violated a slew of other state and federal laws. Blacklists unlawful. To make matters worse, the NVSCA used information about instructors to publish a blacklist on their official website. This information was provided by LVMPD and other sheriff's departments in Nevada. That blacklist is viewable to every one of the NVSCA members, who all happen to be a part of the industry in which Mr. Kalicki conducts his business. The U.S. Court of Appeals has made significant rulings on the issue of governments participating in the practice of blacklisting. We limit the claim to extreme cases, such as a government blacklist, which when circulated or otherwise publicized to prospective employers effectively excludes the blacklisted individual from his occupation, much as if the government had yanked the license of an individual in an occupation that requires licensure. No matter what happens in district court where the case will be heard, LVMPD and the NVSCA are facing some difficult questions. As to Kalicki's belief that the NVSCA are henchmen for law enforcement in Nevada, he did point out that the Nevada Sheriffs and Chiefs Association is having their annual convention at the Las Vegas Mob Museum. And maybe they're just going to pay their respects to a few lost pals.